Next, we have Professor Amnon Reichman from Haifa University. He's an expert in judicial independence, and today he'll talk about judicial independence in the era of algorithms. Thank you.
Thank you very much. It is an honor and a pleasure to participate, albeit via Zoom. I hope I will be able to be physically present in Jerusalem for the festive panel later this afternoon. And I want to again acknowledge the huge contribution of Professor Shimon Shitrit to the field of judicial independence that could not be the same without his contribution and dedication. So I think this warrants a specific mention at the start of my presentation. I want to make two brief comments before delving into the substance of my talk. First, about the title of this panel, measuring the rule of law or judicial independence efficiency versus quality. I think that, of course, these could be two distinct measures. However, I do think that the idea of due process is more helpful. One is due process at the retail level, because judges are committed, or the judiciary is committed to provide due process at the individual level, but that may come at the expense of due process wholesale, not retail, but wholesale, because the more you delve into particular cases, the more you stress the system vis-a-vis the wholesale of future cases, etc. Sometimes it is referred to as efficiency versus quality, but I think that I think due process is a more helpful term. This is point number one. Point number two has to do with the notion of scoreboards, or how do we measure it, and the notion of the EU scoreboard that we've just heard, and the use of technology more generally. I will refer to technology as we go along. I think scoreboards are important, but I'm not sure that a universal measure or a universal scoreboard can be used in a one-size-fits-all. And I'll say what I mean. As we know, because we've been dealing with judicial independence for quite some time now, we could define several axes along which we conceptualize judicial independence. For example, with respect to who controls the judiciary, the management of the judiciary, we have the judicial model, we have the executive model, and we have a continuum in between. It doesn't necessarily follow that judiciaries where there is a strong executive input necessarily in all circumstances are less independent than judiciaries with judicial control, Council of the Judges or Council of Judiciaries, etc. It depends. Why? The point here is, however you design the system, there is a risk of capture. There is a risk of capture. So if you put all the eggs in the basket of the Council of Judiciary, or whatever you call it, and then forces that want to control the judiciary capture this body, it may be more difficult to capture, but nonetheless, through appointments or through some changes, they can capture this, then they capture, it's easier for them to capture the entire system. So the point of, my point here, and this was just the axis of executive versus judicial control over the management of the judiciary. And as we know, this is a key component of judicial independence. Central versus local is another axis. Do we want the management centralized, or do we want it localized in each chapter? It could be federal, it could be state, it could be a local municipal, it could be, and again, it doesn't necessarily follow. It could be the case that if judges, the more local the management of the judges is, the easier it is for local politicians, local powers to influence. Whereas, you know, if you have a very strong national entity, it's more difficult to influence. But that may not necessarily be the case. It could be the reverse. So, and then there are other axes depending or dealing with matters ranging from how do we train our judges? Of course, how do we nominate the judges? That's a structural element that we've always identified. But how do we train the judges? What type of ongoing legal education are judges exposed to? All these measures, if you want, or axes, if you want, may be captured. And then they influence judicial independence. The point I want to raise here, into my initial point here, is there has to be a balance in each jurisdiction that takes into consideration the other axes. So, for example, the more capacity, the more, we call it agentsification in a paper that we've written, the more capacity and willingness to own something, the more you give it to the central, you have to also create a counterbalance at the local level. The more you give the executive, the more you have to give the judiciary. You have to keep the balance, because it's a spatial, the idea of judicial independence has to be understood spatially. It's a space, it's a social space that has centers of power. And then when you want to measure judicial independence more generally, not just quality versus efficiency, if you want to measure judicial independence more generally, the way we've heard just now from our distinguished EU rapporteur, the idea is one critical measure should be how easy it is to capture the system, or how have we built checks and balances configuration within the system, and an adaptive one, a one that can adapt, because powers that want to capture the independence of the judiciary are smart, and they can adapt, and they can say, okay, if we capture this, oh, then we have control over that. And for example, part of the risk is once you get people of your worldview into the judiciary, then they say, oh, I don't think it's a problem of judicial independence at all. You won't tell us, you EU people won't tell us, Poland, Hungary, that our judicial independence is hindered in any way. No, we will tell you, because we see it from the inside. And then you have an issue, once the system is captured, you have an issue of how do we define judicial independence from the inside or from the outside. In any event, my initial point, as I said, is that when we want to think of measures, one measure has to be, of judicial non-dependence more generally, has to be the notion of checks and balances. And the second measure, I want to move quickly, the second measure has to be, of course, the issue of professionalism. And that relates to what I mentioned before with respect to judicial ongoing, and it's very ongoing legal education, and it's very difficult to measure. What do I mean by that? Part of what makes judicial non-dependence so important is the notion of judicial discretion. The idea is that we trust the professionalism of judges to make professionally sound decision based on the law, basic rule of law idea. We have to make sure that there are also checks and balances, professional checks and balances, and these are by definition soft ones. So I'm not suggesting that. So within the system, the idea is that the more professional judges are situated somewhere in the judicial pyramid or judicial hierarchy, and then you have appeals, etc. So you have a self-correcting system within. But that's of course just one dimension. I mean, very professional judges can be situated at the lower levels, and then it's not clear whether you necessarily get the most professional judges, although most often you do, but not necessarily in all circumstances. And in any event, not everything goes to appeal, etc. So the idea to think is to think about checks and balances also with respect to the legal community more generally. The idea that what is called the legal complex is attuned to reading judgments, criticizing the reasoning, being studied in law schools, and then in continuing judicial education structures. The Attorney General's office is a very important component of this legal complex, etc., etc. So there has to be a professional, not just a structural notion of judicial independence, whether it's local, central, whether it's executive, legislative, etc., etc. But it has to be a professional component. Now I want to move to something new that I think I'm going to say, because thus far we've heard issues along those lines before in very interesting conferences that Shimon has organized before, and I see some colleagues I can recognize also my friend Maimon, who's been in several conferences, and others. I don't want to neglect anybody else. I want to introduce the algorithmic dimension, because as I said, we have to think of judicial non-dependence spatially in a social space. And now we have another dimension in the social space, and this is a digital or the virtual space. To think about judicial non-dependence when algorithms are introduced to the virtual space is challenging but important. What do I mean by that? As we know, what ultimately protects the judiciary is the notion of public confidence, public trust, public faith. In other words, there is an institutional capital to the judiciary. The institutional capital contains strong structural protections, as in the United States, but you can never rely only on the structural protections, because if judges issue a judgment and then the executive decides whether or not to enforce it or how to interpret it and what to do with it, we know that in certain jurisdictions at certain times, even in the United States, you had to have an intervention of the United States president, the president of the United States, to send the National Guard to enforce a certain judgment, etc., etc. So the idea is judgments or the law is not just the words. The law is performative. It has to be enforced. It has to be then internalized to the working of agencies in the private sector, etc., etc. And that depends on the notion of public trust, confidence, the institutional capital of the system. And the institutional capital is sensitive to manipulations. And here we have diffuse support, as we know. Caldera told us, and others told us about the diffuse support of the system. Even if I don't agree with a particular judgment or judgments, I nonetheless I hold the system. I have respect. I hold the system in a great esteem, and therefore I follow the judgments and I realize what the rule of law is about, etc. The new era may threaten the diffuse support of the system. And here Shimon realized that judicial non-dependence or judicial independence is related also to world peace. And he, in a way, foresaw this notion that you can have interventions, foreign interventions sometimes, that are geared towards destabilizing the relationship between a jurisdiction and its judiciaries or judiciary. And then you saw discord in the system, and that undermines that system, and it may undermine world peace, therefore. And you can do that now via social platforms and AI. So I'm just flagging this. For the first time in recent history, now the notion of judicial independence or non-dependence may be a component of, call it national security, call it something more, in those lines, where other foreign powers may manipulate the diffuse support of the judiciary, and we should be mindful of that. I don't know if it fits into any scoreboard of the EU or not, but we should be mindful of that. Point number one. Point number two, in that respect, it could also be manipulated internally. If you are of a particular party, political party, you may use social media and other tools. Of course, it's not just social media. You have the print media, you have TV, but the use of AI and social media can augment the ability to manipulate and generate forms of social control, because part of the way this dimension is built is through filter bubbles. So you're being channeled into a certain filter bubble or echo chamber, and you think the reality is like that. But that's a social construct. You've been manipulated and you're not necessarily aware of that. So that with respect to the system as a whole, it is equally, if not more dangerous with respect to the individual judge, because now we can use AI in order to anticipate the performance of individual judges. Is this a threat to judicial independence? On the one hand, maybe not. Maybe if we use AI to know the judge so-and-so, she's very responsive to certain legal arguments, maybe what we should do, and it's not a threat to judicial non-independence, we should just phrase our case in a certain manner so she will be more responsive to our arguments. But on the other hand, there clearly could be a notion of judicial non-dependence because there's an issue of manipulation here. Nobody's aware of what we're doing. Nobody's aware that we are just using our resources in a certain way so as to steer the judge to get the decision we want the judge to achieve or to reach without nobody knowing. So there's an issue of transparency here. The issue is that this happens behind closed doors by algorithms that are not transparent. We don't know how they're being used. And it's a clear issue, I think, in that respect of judicial non-independence. Brackets. I open brackets now and I want to respond to the beautiful presentation by Professor Dom that we had before. And how did he call it? He called it the highest tech advancement in court when we talked about DNA. I think algorithms more generally could be the highest tech invention in courts. We have algorithmic judgments now being considered. So I will get to that in a second, but more importantly, I think we should know that the technology is being used or misused and how it is being manipulated. The same way DNA can be manipulated, because Professor Dom earlier thought that now the suspect has to explain how his DNA is found in the field. Well, maybe it was planted there. Who knows? I mean, the technology can always be manipulated. As soon as it is technological, you can have artificial DNA. It's very, in certain ways can be manipulated, or DNA can be extracted and then transplanted. It's very difficult once technology gets into the field. I have only a couple of minutes to conclude. So I want to suggest that, to conclude by saying that judicial non-dependence is always a conversation. It's an ongoing process. So we need you, Shimon, for the next 75 years at least, to continue your leadership, because we are always going to have new challenges. And then in Poland, they're going to be very creative, or in Hungary, they're going to be very creative, or somewhere else, they're going to start to be very creative. And then technology is going to be very creative, because now, and that's my concluding, now even what it means, what is judicial non-dependence is being problematized, because some judicial functions are being performed by machines. In the UK, we know that some decisions that are judicial decisions are being processed via machines. When you buy stuff on Amazon or eBay, there are algorithmic dispute resolutions. In courts, some algorithms are being deployed to assist judges to make decisions. How should we think about judicial non-dependence in that respect? So the conversation is just beginning, and I want to thank the opportunity to address this very distinguished conference, and wish us all a very fruitful future conferences like that. Thank you.